128.
My lord, I can note 27. That petition which I filed, there is some defect in the prayer.
Which matter are you mentioning?
Item 27.
27.
27.
27, all right.
Yes,
Yes. What do you want?
Actually, I want to file a fresh petition, my lord. I want to withdraw
Withdraw
this with the liberty to file a fresh.
All right. So he's Mr. S. Mitra.
Yes, ma'am.
Mr. S. Mitra. Mr. S. Mitra, learned advocate for the petitioner, seeks permission to withdraw this application in order to enable the petitioner to file a fresh application. Dismissed as withdrawn with the liberty of
Yes, ma'am.
This is item number 27. All right. Yes.
Item number 9 to 17. Item number 18 to 31.
Yes, please, your lordship. I have to mention item number 15, lordship.
Yes.
The senior is physically not well.
It's a delay of 1 day. Wait for your turn. Let's see. Wait for your turn. If either we notice or we condone the delay. So tell your senior that in his absence you have got this petition allowed. Any difficulty?
Okay, lord.
So wait for your turn. Yes.
May it please,
Yes.
pray for urgent listing tomorrow, no, urgent matter.
No, all mentionings are over.
No.
Please wait for your turn. Please wait.
Item 18 to 31. Anyone for 23?
No, please, your lordship. In this case, I am just seeing
Which case?
23.
Hmm.
In
German slip has been circulated. All right. All right. May, June, whichever.
28 May 20. From item number 34 to 43. Adjournment request.
Lord, in 34, my lord, I am have some difficulty today. So can I give money on any day? Because I was out of station, just reached in the morning. I couldn't even go through the file. Personal difficulty.
In item number 34 and 35,
Yes,
have you informed the other side?
yes.
All right. As prayed for on behalf of the appellant. In WA number 246 of 2025, let this matter come up for consideration on your date
27th of April, my lord.
and let WPC number 4378 of 2024 be listed along with the aforementioned.
27th April, my lord.
Hmm?
27th April.
7th of April. It depends. I think it will go in May. Keep sometimes in May.
11th May. 11th May.
Yes.
I beg to item 43, we have already circulated the adjournment slip.
German slate has been circulated, all right.
Cannot be on.
12 May.
Obliged.
Any other request?
Five.
45 wrongly listed.
45 is not even printed. It has been deleted.
Wrongly listed.
May it please,
Yes.
urgent listing tomorrow. Deeply.
No.
No,
But you still to get that order from us.
sorry, sir.
Urgent listing for what? Which
No, no,
matter? Why?
Mala, the infrastructure project has been stayed. Mala, there's a deadline. Tomorrow is the last day. That
Infrastructure project has been stayed by a single judge.
yes, ma'am. Yes, ma'am.
On what ground?
Mala, on the ground that Mala, there was an earlier order, my lord. I have to narrate the facts. What had happened, my lord? Initially, I was granted the work, and my work was terminated, my lord. We approached the court challenging the order of termination and the reallotment of work to some other contractor, my lord. Now, when we filed that writ petition, the learned single judge had held, my lord, that single judge has held that he would not interfere with the order of termination, but insofar as the reallotment of work was concerned, my lord, he had held, my lord, there were gross illegalities. So an inquiry was directed, my lord. Pursuant to that fact-finding inquiry, my lord, it appeared that my cancellation was without jurisdiction. No notices were served to me. notices were forged in.
Finally,
And thereafter, my lords, I was restored back to the position, my lords, because it was vitiated by fraud, and I was allowed to work, my lords, the remaining work, my lords. That was stayed only on the ground, my lords.
the termination of your agreement, was it revoked?
The termination was again, my lords, it was reviewed by the department upon establishment of fresh facts that the termination itself was illegal, my lords, and thereafter I was allowed to complete the work.
Allowed to complete the work is something different. That stage comes only when when the termination is interfered.
Yes, yes.
Has it been interfered?
Termination was interfered by the department, my lords. They decided, my
All
lords.
right, by the department only.
Yes,
and
yes,
that
yes,
was not
yes.
never questioned.
Yes, yes.
Was that,
I was allowed to work.
then what happened?
When I was allowed to work,
Then what happened?
the person who was reallocated the work, my lords, without
Yes.
tender, he approached the honorable court, and my lords, one of the grounds were that in the earlier case, there was a finding that the single judge did not interfere with the order of termination. Only on that ground, the infrastructure project has been stayed, my lord.
Yes, tomorrow.
I'm very grateful, my lord. I'm deeply obliged.
Daily list for this item 1.
Please consider that not to take the
Yeah, please, your lordships.
Yeah.
Lordships, this instant contempt petition has been filed
Yes.
as the respondent authorities have failed to comply with the
Let's see the order.
page 52 minute. Paras 13 to 15.
Clear order, page 52.
52 minute.
This has not been done.
Not till date.
He led counsel for the petitioner. Admits that by judgment dated 2/4/2025, past tense, WN 231 of 2024, a bench of this court, after having set aside the order dated 12/6/2024, directed the respondents, particularly the state selection board, to consider the matter pertaining to recruitment against the post of principal, Hovajan Higher Secondary School, Vishwanath, afresh, and submit a fresh recommendation in that regard. The contention of the petitioner is that nothing has been done pursuant to the aforementioned direction. Let notice be issued. Would be the answering respondent.
Let the
Notice be issued to number 1 and 2 on steps being taken by the petitioner within a period of 2 weeks, both modes returnable May 1st week.
6th May. Item 2.
First time it's coming.
my lord,
Private respondent.
my lord. My lord, earlier I had filed an application.
Application for delay. Condonation of delay of so many days. Full application. Notice to
My
respond.
lord, a small submission, my lord.
Yeah.
My lord, I think that there is a typographical error in paragraph 9,
Paragraph 9.
page 5, my lord. Lordship will see page 5.
What is that?
My lord, the certified copy of the judgment dated so and so on dated so and so on 5/2/2025. There needs to be some.
You have left it blank.
Yes, my lord.
So what is the number of days
My
delay?
lord, on the same day it was obtained, my lord. 48 days delay is there, my lord.
Doesn't matter. Doesn't matter.
Fine.
Doesn't matter if they take up this plea that it was the blank was not filled up by the applicant. We'll deal with it.
I'm a blind.
Both modes, notice to respond number 1. Full respondent, both modes returnable, sometimes in the end.
Deeply observed.
22nd May.
Full detail.
Item 3 to 5.
We basically order to report the
Notice has been served.
Raise to every.
Lordship, item number 5 has been wrongly taken up, Lordship. It should be separated, Lordship.
Some letter on this matter is basically listed for the three. That report says that it is delivered to the.
And in pre-Lordship, notice has only been, steps have been taken on 20th of February, Lordship.
Yes. The tracking report that there are how many respondents?
In item number 3, Lordship, sole respondent, only one.
That the respondent has been, the respondent has been served. Awaiting the appearance of the respondent in this matter, the case is adjourned to so and so date, on which date it shall be listed under the heading admission. How about 4 and 5?
Four service is complete, Lordship.
In respect of item number 4, my lord, service has been completed. I am appearing on behalf of.
Since service is complete in WPC number 2256 of 2025 and WPC number 4877 of 2025, let these two petitions also be listed along with.
Lordship, 5 has been wrongly taken up, Lordship.
We'll see on the next day. Listed along with WPC number 857 of 2025. Give or take, sometimes May, June.
8 June. Item 6.
Yes, you're not interested.
No, Lordship,
He appears. Whom do you appear for?
On behalf of the respondent, my lord.
Sole respondent.
Sole respondent.
All right, since you appeared. Despite the fact. Pardon?
My senior,
But we are not asking you to argue now. We say that the service is complete, therefore it shall be listed for admission. Doesn't matter. Doesn't matter since you're appearing, we take it that you've been served. What is your name?
You say it.
Huh?
You say it.
Mr. U. Cycle and an advocate has appeared on notice on behalf of the sole respondent and submits that the wakalatnama has already been filed in the registry. With the service having been completed, the matter requires to be listed for admission. Let this case be listed for admission on give a date. The name of the advocates for the parties ought to be reflected in the court list.
That's
Ought to be reflected, Mr. Saikia, where are you in the morning? Are you here or somewhere else?
5, 6.
This happens when you're somewhere else and physically you're present here.
Lord, I apologize.
That is what we are saying without your asking.
I apologize.
Correct. Don't apologize. I mean, there's nothing wrong that you've committed. We are just indicated to you. We are passing the order without your asking.
My lord.
Yes.
Item 7.
Since seeking the connotation of delay of 82 days, madam, filing the
Who
appeal.
appears for the High Court?
Not I'm appealing.
Accept notice.
Fine.
There's an application seeking confirmation of delay of 82 days in preferring the appeal. Mr. Das. Mr. H.K. Das, learned advocate for the Gauhati High Court, accepts notice. So in case any reply affidavit is required to be filed, that may be done on or before the next date. Re-notify. So,
It's going to one.
11 May.
Much obliged.
Item 8.
21 days delay.
21 days.
Who appears?
C is there, madam.
Two and four, respondents, so all of you accept notice.
I'm waiting for April 3 and 5.
So and so notice accepted by so and so. In case it is deemed necessary for the respondents to file any affidavit in opposition with respect to such prayer for confirmation, that may be done on or before the next date, we notify 2 weeks.
28th May. 20. Item 9.
You are present here.
Madam, we are not objecting, madam.
Huh?
We are not objecting to the termination, madam.
Okay,
today.
there's an application seeking confirmation of delay of 41 days. The letter counsel for the respondents are on caveat and are present today. The grounds are genuine. The delay is condoned, application allowed, appeal to be processed. Pura detail. All right.
22nd May.
Can it be a little early, Miller, because the child's admission is on stake because of this Miller order.
Early May.
8th May.
Oblige, deeply oblige.
8. Item 10.
Wait, to the lot.
Who appears for the state?
Government.
Would you respond or do we condone? What date? Do you have any objection? If you don't have any objection, we'll cut short the matter.
I don't obtain instruct.
This is accepted by Sumatra Sharma, Leonard Government Advocate. Government Advocate. Any affidavit in operation, if deemed necessary, may be filed on or before the next day. We notify 3 weeks.
Apply.
15th May. Item 11.
Eight days, all of you accept notice, all government employees. Delay can give a slip, a delay condone, application allowed, appeal to be processed.
Lordship, take the matter on 12th May.
Yes,
Lordship, kindly take the matter on 12th May along with the read appeal number 1.
please don't ask for that. We can't set the calendar according to your time.
25th May.
Time will be
Just
given.
like right. Lordship. Item 12.
All Same order.
Same date. Item 13.
13 days. All.
Item 14.
264.
May I proceed? I put a sole respondent, KVS.
You're here. You want to file?
Yes, Lord, I filed because 264 days.
So things. Keep on filing. Challenging, opposing the prayer for confirmation of the affidavit must be filed on or before the next date, re-notified 3 weeks.
29th May.
Can it be a bit earlier?
I don't think, but the petitioner is also not present.
I'm sorry. There's a delay.
He has accepted the notice, he shall file.
Item 15.
Oblige.
1B, government 1 to raise temporary council.
1 day's delay, once on notice accepted. Delay condoned, application. You are asking for time, we are condoning the delay, appeal to be processed. Tell your senior. No notice also is required, they have accepted notice.
1st June. Item 16.
56 days delay, Lord.
Notice to the respondent, both modes returnable may.
Okay.
Twenty-second May. Item 17.
70.
You have accepted.
I'm waiting for a
File your affidavit.
We will file our objection notice.
So and so appears for the respondent who seeks to file not to oppose the prayer. Let that be filed on or before the next day, 3 weeks. 3 weeks.
15 May. Supplementary list, item 46.
Where please an option? Judgment is not about this. It is the subject matter. Malad, may I kindly have page 48, my lord. Page 48.
Page 48.
Yes, my lord. My lord, the name of Honorable Justice Mr. A.G. Chaudhary is appearing, my lord, in this order, page 48.
Okay, let this case go out of relation. Then be placed before an appropriate bench of which one of us, each or each is not a part. Give this case back. Chief Justice. The administrative side of our bench, of an appropriate bench.
47 same.
Same. What is it?
For admission, item 18.
Okay, so Lakshmi. In this case, the learned debt recovery appellate tribunal has passed the interim order on 5/2/2026, thereby condemned the delay application filed by the respondent bank and stayed the operation of the order passed by the learned debt recovery tribunal Gauhati, wherein the learned debt recovery tribunal has passed an order directing the respondent bank to issue no due certificate to the petitioner.
Just a minute.
Yes, ma'am.
Take a the petitioner, a private limited company, engaged in production of ice cream and similar products, took loan from the respondent Union Bank of India, which could not be repaid on time. As such, the loan account was declared NPA. The creditor bank filed an original application number 333 of 2022 before the DRT Gauhati, claiming an amount of rupees 72,32,349 as dues against the petitioner as on 30th of June 2022. No sooner the petitioner received notice from the DRT, all the outstanding dues were cleared in 2 installments by 21st of November 2022. With this settlement of dues, the DRT Gauhati directed the creditor bank to issue a no dues certificate and refund the excess amount if paid by the petitioner. So this direction was not complied by the respondent bank, and instead a review application was filed before the tribunal seeking modification of the order. The review application came to be dismissed on 23rd of June 2025 with another direction for compliance of the order referred to above within 2 weeks. The the respondent bank chose to challenge that order by two separate appeals before the appellate tribunal, Kolkata. One with a delay of 9 days against 23rd of June 2025 order, and the other with a delay of 247 days against 28th of October 2024 order. The respondent bank also sought stay of the DRT's order. The Land Council for the Petitioner submits that on 5th of February 2026, delay in filing both the appeals before the appellate tribunal was condoned. The appeals preferred by the bank were admitted, and the order passed by the DRT on 28th of October 2024 was stayed. We are at a loss to understand as to what was the necessity of staying the order when admittedly the entire due had been paid. And there was a direction from the DRT for refund for issuance of a no due certificate, and in case of any excess payment, refund of that amount to the petition. Let notice be issued to the respondents on steps being taken by the petitioner within a period of 2 weeks, both modes returnable within 4th week. We have heard MS P. Goswami for me. There's no need to stay that or stay order. It doesn't matter.
20 seconds. Item 19.
The matter may kindly be passed over for finding.
Kindly hear it tomorrow as prayed for on behalf of the petition. Let this matter come up for consideration. Or if you want a longer time, we can give you a longer time.
My lord.
If you want a longer time, we are ready to give you a longer time.
No, my lord, tomorrow.
Item 20.
Please, my lords. My lords, I'm appearing virtually. If my lords will have the last order of the 21st of January, my lords had directed that the government place the details regarding the victims of Nelly massacre and that they are collating a list, if my lords will recall. Nothing has come on record.
Recall the arguments having been advanced by the petitioner. We recall that the Advocate General had appeared in the matter, and without any direction, the Advocate General had submitted that the information regarding the victims of Nelly massacre would be collated from different districts, and a consolidated affidavit shall be filed by the next day. Correct. There was no direction.
Yes, my lords, of course.
There was no direction.
I bow down to that, my lords.
That's all right. But today, take a view. We would be justified in taking the view. Maintainability, yes, because it's a continuing wrong. But then the prudence demands that this be left in the domain of the executive. The executive decision to get into all this. And no judicial scrutiny would be required. Because otherwise,
yes.
4 decades.
Yes, my lords.
There will be evidentiary problems. How to seek that information?
Please, my lords.
There will be no certainty.
Yeah, my lords is absolutely right. Although, my lords, may I only submit one thing here, that the state already has lists that to who the compensation was given. We are not saying expand it or include any more new people, which is why, my lords,
You may not be asking no.
Yes, my lords.
But any order passed in terms of what you're praying would have a downstream effect which we must guard against.
my lords, very well. May I only say one thing? My lords, we have come this far because of my lord's bench, and the state had said that they'll place this affidavit. My lords, please ask them to at least put the affidavit. Once my lord sees, whether there's a collated list, how many victims are there, then my lords may make that decision on that date. I'm only requesting because, my lords, we had moved the Supreme Court in a 32.
MS Farasat, you must understand one thing. It is very difficult to pass any judicial order giving any direction for making any enhanced payment after 40 years. See, the difficulty ongoing and everything we understand.
Yes, my lords.
We have many cases also. That time you referred to
Yes.
this 1982 matter, public democratic rights, then Padwa Mukti Morcha, Narmada Bachao Andolan, all
Yes.
these references we understand.
Yes, my lords.
It's a continuing wrong.
Yes.
And public law remedy is enforceable even after the event, long time after the event. We understand all that. But the
Yes.
practicality tells us that it cannot be interfered with.
My lords, may I
For
only...
the stainless
yeah.
of the case.
Yes.
Anyway,
My,
since the Advocate General had said that a list would be some list would be collated and brought before this court, let's have it. Have you brought it?
yes, my lords. I think let's keep it for that. I'm grateful for that accommodation.
Lordship, we will receive instructions, Lordship, which is the complete Lordship, sometime maybe 22 hours, Lordship.
As prayed for on behalf of the state, we notify. We are not saying all this, but we are only adjourning the matter. But
All right.
put it on affidavit from the next state, we must conclude.
Lordship.
As prayed for on behalf of the state, let this matter come up for consideration for the date in June. All right.
15 June.
My lords, may I just request for a shorter date? My lords have been very kind to us. Give us something in April. I will also come down myself. My lords, in fact, there are 3 or 4 judgments where they have given...
You can tell me those judgments. I've been remembering those judgments. In
My
public.
lords, in the Muzaffarnagar riots, there is a judgment in that. And also, my lords, one important thing is that in 2019, the Assam government had increased and enhanced the compensation for people who had suffered during the AGP movement. So that again had happened for instances of 1983 violence. In fact, that is one of the reasons that we are in court.
Which date we have fixed?
15 June.
15th of June. We'll do it sometimes in the end of May.
Yes, my lords, I'm grateful for that.
April would be difficult.
All right, my lords, mid-May also, after the election results.
May.
Lordship, it will be better if it's posted in the month of June, Lordship, because we are receiving incomplete instructions, Lordship. Something
That day, if you have any difficulty, tell us.
Lordship.
22nd May.
Grateful, my lords, grateful, very grateful.
Item 21.
Yeah.
Lordship, according to the Maintenance and Welfare of Parents and Senior Citizens Act,
That Act 91 says what? This 2007 Act, Maintenance and Welfare of Parents and Senior Citizens. You have a copy of the Act?
Lordship,
How come have you argued this case? Young lawyers, instead of getting this decided, what kind of petition have you filed? PILs? I mean, similar such PILs are pending. And you don't have the section, don't have the Act also. We dismiss it now on this ground only. Take them. We are not dismissing it, we are asking the state to respond. But then, come on with these. This public interest litigation has been filed by a practicing advocate of this court. With the charge that 3 of the state governments under the jurisdiction, 3 of the state governments, namely Assam, Mizoram and Arunachal Pradesh,
Nagaland.
Assam, Mizoram, and Nagaland have not set up any old age home. Any old age home in accordance with the mandate under section 19(1) of the Maintenance and Welfare of Parents and Senior Citizens Act 2007. The provision, the aforementioned provision of the Act places a mandatory obligation on every state government to establish and maintain old age homes. So it requires the states to start by setting up at least one old age home in each district, located at accessible places, with a minimum capacity to house 150 indigent senior citizens. The states may also set up more homes if needed. But according to the learned counsel for the petitioner, the states must begin with this minimum requirement in a phased manner. The information regarding no such old age home having been set up by the three states of Assam, Nagaland, and Mizoram has been collected through RTI response. Let notice be issued to the aforesaid two state governments, aforesaid three state governments of Assam, Nagaland, and Mizoram. Learned standing up, learned for Mr. So-and-so, Mr. So-and-so, Mr. So-and-so, accept notice on behalf of the respective state governments and submit that clear response shall be filed to this petition by the next date, June.
Lordship, here Arunachal Pradesh is also in party, Lordship.
Arunachal is also part.
Lordship.
So not three supported states.
But no RTI reply was furnished to him, Lordship.
Jawab do na. RTI, what RTI? You are the custodian, you know everything. Unnecessary. File, if not initiate the process. That's all.
Lordship.
That's a mandate under the Act. You think it to be adversary litigation? Please, you're mistaken. 91 casts an obligation on you. Do that. Start doing it.
Lordship.
10 June.
Deeply obliged.
Obliged, Lordship.
Item 22.
Yes. Give us 1 minute.
The
Let us sleep.
order I have challenged one of the page 112, 100.
We don't know. Nothing can be done here.
Just a minute,
We
Lordship.
don't find fault the single judge's order.
Kindly see at page 112,
we were not made party to the case. Whether order has Lanak Singh was misled because I am the borrower of the bank and I am the owner of the building. That page 112, order was passed.
The single judge issues a direction to the bank only, not to you. It issues a direction to the bank that when you have auction sold a property which was mortgaged, somebody has purchased it, deposited the price, possession has not been given. Give possession.
Lordship, can you see?
Second.
Direct.
That is over. There's a fresh order structure when we purchase an auction property in for this like.
Space 114. The space 114 can be seen. 114.
How do we actually do this?
No,
You are the direction was to the bank. The bank could challenge.
No, that not the direction. It kindly see page 114. 114, Mother. The order 114. The requisition accordingly goes in the direction to hand over the possession. To hand over the possession, Mother. Accordingly, the possession, if the possession is handed over, what will be my fare? Kindly see. The revenue accordingly goes in the direction to hand over the possession of the property in question to the within.
If we want, Mr. Saikia, we can also affirm this order and say that please hand over the possession of the property to the auction purchaser.
My lord,
So keep it doubly enforced. We are not interfering with this.
my lord, just a minute. Lordship, the failure of the process was wrong in the original case. Just a minute, my lord. Just be kind enough. Be kindly see, my lord, the grounds in which why I have challenged you. The page.
Just a minute. Don't gesticulate. Can you be kind enough to understand our limitations in not interfering in this matter? We are not kind. We would be gracious in hearing you. But you be please kind to understand that after all these orders, there is nothing left for us to do, notwithstanding the fact that we find that you have been dealt with harshly. Because out of 3 crores, 56 lakhs you have paid. Not that we are not aware of the facts. But what can be done now? How do we recompense? How do we protect the interest of the buyer? The whole system gets haywire.
I did not get the chance to ventilate my grounds before the landed civil judge. Order of an expert order, Lordship. Secondly, the purchaser, knowing very well, he has suppressed the facts and moved the requisition. Whereas I have to pay rupees 87 lakhs. The value of the building is rupees 350 lakhs. Relation the compulsory kindly see the grounds. Kindly, no, that's you Lordship will kindly see the ground. At press 25. Press 20, press 30. My Lordship kindly for the ends of justice, press 30. For that in the for that in the review of petition number so and so, which is pending before the landed Gauhati, the valuation report of the building meant by the concerned engineer, which was more than rupees 350 lakh, has been placed, but the same was suppressed with the requisitioner as well as by the respondent bank. Value of the building and land is 350 lakhs, and I have to pay rupees 87 lakhs, but I paid 56 lakhs. So when I deposited 56 lakhs at Calcutta, my lord, I should be allowed regarding the valuation of the, and it is a compulsory under Rule 9. Can you see, my lord? All procedure wrong in the trial court. What you can see here, page 34. Page 34, ground. Ground number P. Further, the time for depositing the bid money as per Surface Act by the bidder is 90 days. That's it. The 90 days, but it took 3 years. And then we can nullify the intention and valuation certificate can be similar. At page 36, paragraph para 5. Para 5 rule. I have asserted the rule. I was not there in the trial court. Para 5. before effecting sale of the involved property, referred to in schedule 1 of the rule 9, the authorized officer shall obtain valuation of the property from an approved valuer.
For how long, Mr. Saikia, would you test the patience of the court? You are showing various pages of the brief. We are asking you to come to page 205.
Hello?
We are asking you to come to page 205. Now, did you not get an opportunity of arguing all this before a division bench of this court when you challenged the vacation order?
No.
Now, do you want the court to go all over again and decide? I mean, you should also advise your client appropriately. No, we are being kind and gracious. You also be kind to us.
My lord, lordship, at that
आप मेरी
time,
patience को stretch करिएगा तो बहुत मुश्किल है.
no,
We are hearing you, but why can't you answer this? And why should cost not be imposed on you?
no, at that time, the landlord.
No. Why cost should not be imposed on you? Tell me, Mr. Saikia. Look at the order dated 4/12/2025 by a division bench of this court. Did you not get an opportunity of saying all this, that one of the mortgagors, one of the what is it? One of the guarantors was in jail, therefore he was not personally serviced. I mean, given notice. Now, all these grounds you had the occasion to argue before the division bench, and you have again come without telling us all this. And now you want us to adjudicate again. आपको मैं इतनी देर से सुन रहा हूँ, आप इतना आपको kindness की पाठ पढ़ा दिया.
My lord, lordship is correct from the point of view.
Correct. So you're telling that we are correct. So please accept our correct order.
Lordship, the 10 lakh rupees he paid, 3 lakh only.
This is not the forum, sir. यहाँ इस forum पे you can't have such. This is no bargaining counter, no. So we can't ask the bank here because everything you had the occasion to agitate all this before before the DB2 when you argued the matter. तो अभी क्या करेंगे?
Correct.
Correct. So correct, you accept the order that there is nothing on this, so we dismiss it. नहीं हो सकता है ना? No matter how much indulgent we may become.
Let me withdraw it.
Huh?
Let me withdraw it. Sorry. Let me withdraw it.
Are you withdrawing it under any pressure from the court, or are you withdrawing of your own?
No.
We would not impose cost.
Actually, I was not there at that time.
That's all right.
Because when
All right.
Honorable High Court was pleased to ask him to pay rupees 10 lakh, he should have moved a petition for extension of time. He did not do it.
So you want us to dictate the order? If you don't want to withdraw because you have already appeared in a matter, we will dictate and be done with it.
Let me withdraw it, my lord, because otherwise, because I don't want to bring the, my lord, that the client, let him understand that he should have deposited the 10 lakh rupees. I one day asked him, why you did not deposit? He told that I was ill. But you should have informed the honorable court by begging time.
Yes.
Begging time that let me 7 days time be granted. Only my grievance, only small grievance that building cost is rupees 3 crores 50 lakh. And the fellowship certificate was not followed by the landed trial court. That was the ground. He
should have engaged you in the first instance because Mr. Saikia was not there for all this background. After some arguments, Mr. Saikia, Mr. R.C. Saikia, learned advocate for the appellant seeks permission to withdraw this application. Dismissed as withdrawn.
Obliged. Obliged.
Item 24.
Yes, Mr. Chaudhary.
Lordship, similar issue Lordship has decided some time back. Not decided, Lordship has issued notice.
Where is that order?
Unfortunately, Lordship, this order has not been uploaded yesterday night.
How come?
I have not found yesterday night.
How is that possible?
158026
are uploaded on the same day. Where have you gone wrong?
I could not find Lordship. I searched for it yesterday night.
Number बताइए. ऐसा
1580 of 26. Rajesh Kumar Suma.
No. Order passed when?
It was passed on 18/3/26.
कैसा हो ही नहीं सकता है this?
I don't know, Lordship. At least it was not coming in. Lordship.
नहीं है. Mr. President. कैसे लिखाएंगे इसको? तब डेट ऑर्डर I think we gave some introductory.
Yes, it's lordship, so far as
And we have
fixation.
also stayed.
Yes, so far
I mean,
as the
so
fixation.
Did you not come immediately after the second day? We dictated here, no?
Yes, yes, no,
Why
lordship.
was it?
I thought it would be uploaded, lordship.
Order is not uploaded. Why? What's the file? Who took the picture? I will not proceed further unless the order is uploaded now. Mr. Chaudhary, wait for a
Yes, yes.
wait for a while.
Yes.
आप किसी को भेजिएगा have the file. Get the file. Well, this is unpardonable. When we don't pick the register, we only say that everything. We only ensure while leaving the spot that everything has been uploaded. She say yes.
It might be some technical difficulty, lordship.
I don't know, but it should not. This complaint should not come before you.
Lordship, I'm not complaining.
You are not complaining. This I'm sure you are not complaining. That the court is absolutely conscious of the fact that orders should be immediately uploaded. We have it uploaded even in the late night on Saturdays. Yesterday also we have got many orders uploaded. ये फाइल इसको भी रखते हैं. Just wait for a while. क्या करते हैं? Anyway, चलो आपका था Mr. Khan. But we are not going to say anything, but it must be uploaded before I take up that case. Check करके हमें 10 मिनट में बताओ. But my mind would be stuck on that. Yes, next call.
Madam, in this case, my lord, the outstanding of the petition as unpaid, my lord, rupees 10 lakhs.
Let me take instruction, my lord, not prevent of their house rent, my lord.
आप हाई कोर्ट का नाम खराब कर देंगे.
My lord, I'll take instruction.
You, Mr. High Court, you will spoil the name of the
No, my
Mr.
lord.
Manta.
Yes, my
Who will
lord.
give the house on rent for judicial officer?
Exactly,
If
my
you
lord.
don't pay,
That's why I will take care of it, my lord. I'll take instruction. But some amount has been paid in the last, my lord, month of July 2025.
This is, I think there is another case.
Yes, there are 5 cases, my lord. There are another
Another
one.
case, 109.
Today there are 2 cases, earlier one, my lord.
That we have fixed some.
24, my lord.
Yes, my lord, after my lord, after the order, my lord.
25. Who appears in 26?
I am my lord. Same method.
Same method.
Yes, Mr. Mr. T.J. Mohtar, senior advocate for the High Court, seek some time to look at it
My lord.
and respond as to why the rental for the house given by the petitioner for accommodating judicial officers has not been paid as yet. Notify on. और दूसरा वाला कब है date?
My lord.
Next,
24 4, my lord.
24th of
24
April.
4. WBC number 1109, my lord. In other advocate, my lord.
इसको कर देते हैं. You keep it in April.
My lord, one thing, my lord. In the synopsis, my lord, the number of the amount has wrongly button.
Doesn't matter. Even if it is 500 rupees, it must be paid.
Yes, yes, definitely.
Obliged, sir. Highly obliged.
Relax, just a minute.
Highly obliged, sir.
Noted.
Okay, 27. Yes.
One, it is the impute order of the PAT, my lord, Gauhati. Issue is the compassionate appointment, my lord. The petitioner is all dependent And but this of death, honorable death has says that he is not entitled to get the compassionate appointment because one lady, she has appeared claiming herself the wife.
She is not an unknown lady. She is the wife of the son of the person who died.
Yes, my lord.
Correct. And there is a small son also.
My lord, yes.
Where is the mistake of the tribunal?
My lord, mistake is my lord that one legal. I have sympathy for that. But legal points is that my lord, the person's son, she has not regularly appointed, and there is a condition that you complete your education qualification. Then, but before that he died. Now this daughter, this original, the father is the original regular employee. The petitioner is the sole, my lord, legally competent person. My lord, that's extraordinary.
Or that line ended with even irregular appointment having been, or casual appointment having been given to the son, your brother.
Yes.
Right, that line ended now.
My lord.
Now anybody who is to be treated as an heir, if at all, would be his son.
My lord.
But that also they will not be able to give it to him because he is too old, and your rule says the government of Assam has come out with a notification that if it is not done within 5 years, it goes. But we don't find any fault with the order.
On page 86 says that his family is the sister, not the wife or son, my lord. There is a declaration. So
We are not. We are not inclined to interfere.
There are 5, my lord.
We may not agree with the reasoning of the tribunal, but the fact situation is such that we cannot interfere. We can't do anything. And unless we will not enter into fields where the road ends.
That is the question. Para 5 of page 86 says, this tribunal says that whether marriage was not done because he was minor, that son is minor.
Why do we get into that controversy?
That factum is not there also. This by not sure what is marriage was done or not.
Okay. Mr. Railways, Mr. Councillor for the Railways, it's a very clever ploy. You will not give appointment to her, and you will also not give appointment to the young son who would come of age after say 10 years, 12 years, 13 years.
By the way, the simple fact is that after the death of Pankaj Chandra Das, who happened to be the government employee, by Lord, a specific affidavit has been filed by the present petitioner and her mother that they are not going to claim, and they did not have any objection if the son of the expired government employees granted compassionate appointment. That is point number 1. And after the demise of Prafulla Chandra Das, my lord, his wife, Maya Das, used to get the pension. And their pensionary benefit has been
Written response. File your response.
deeply obliged, my lord.
Take it. We have heard Mr. J. Barua, Mr. M.J. Barua, an advocate for the petitioner, and Mr. V. Deka for the railway. The challenge in this petition is to the order dated 2nd of September 2025, passed by the Central Administrative Tribunal, Gauhati, whereby the claim of the petitioner for being appointed on compassionate ground has been rejected. This case reflects an unfortunate successive deaths in the family of the employee in Prafulla Chandra Das, who served the railways as technician grade 1 mechanical at New Bongaigaon. He died in harness on 6th of July 2014. At the time of his death, his family comprised the petitioner, bracket daughter, her brother, Pankaj Das, son, and the wife of the employee, namely Maya Das, bracket widow. At that time, the petitioner, bracket daughter, was the only one in the family who met the educational qualification requirement for the job. But according to the petition, the railways, the respondent railways, processed the case of her brother instead. So be that as it may, the petitioner and her mother both gave a no objection certificate so that the son of the employee, namely Pankaj Das, could get a compassionate appointment. The case of the petitioner is that Pankaj Das was given temporary appointment without any regular pay scale on the condition that he must acquire the minimum educational qualification within 5 years, failing which his services would not be regularized. As ill luck would have it, the mother of the petitioner, that is the widow of the employee, died on 8th of January 2018. In quick succession, Pankaj Das also died on 7th of March 2018 without acquiring the requisite educational qualification. Since the appointment of Pankaj was only temporary and never became regular, there was no way in which his services could have been confirmed. The contention of the petitioner is that after both her mother and brother having passed away, the petitioner was the sole surviving legal heir of her father. In that capacity, she made an application for compassionate appointment in her name, which claim was rejected by a speaking order on 1st of October 2021. The reason assigned for rejecting the claim of the petitioner was that Pankaj has a wife called Sagarika Das and a minor son, Ayush Das, from the marriage. The inquiry conducted by the railways reflected that the claim of the widow of Pankaj, or for that matter, her minor son, has to receive precedence over the claim of the petitioner. The petitioner, under such circumstances, approached the tribunal, which directed the railways to consider her representation and pass a speaking order. With the passing of the speaking order, about which reference has been made in the earlier paragraph, the petitioner filed a second OA number 291 of 2021, which was dismissed. The tribunal in this instance observed that the petitioner was already receiving a family pension of rupees 13,230 per month, even before her brother Pankaj had died. And therefore, she was not in dire need of being offered compassionate appointment to tide over the difficulties. The tribunal also held that the minor son of Pankaj, namely Ayush Das, would be entitled to compassionate appointment against such compassionate appointment when he comes of age. These observations and the decision of the tribunal have been challenged by the petitioner on several grounds. Mainly, that says her brother was not a regular employee. The compassionate the right to be appointed on compassionate ground would not flow to his wife or son. And that in all official declarations made by her brother slash Pankaj to his employer slash railway department during his lifetime, he referred to the petitioner as his family member and never disclosed the fact of the existence of either Sagarika or Ayush. The further contention of the petitioner is that she is a divorced daughter of the late employee who was fully dependent on her father since 2009, since divorce, and continued to be dependent on the family even after his death. The further contention of the petitioner is that the tribunal missed out that railway rules and government notifications treat a divorced daughter as part of the family and eligible for compassionate appointment. It was thus argued that the tribunal wrongly assumed that the minor son of Pankaj had a superior or future claim, even though Pankaj himself was not a regular employee, entitled to pass on any such benefit. Mr. Dekka, a counsel appearing for the railway administration, submits that he shall respond to this petition by the next day. Let the requisite affidavit be filed positive on or before the next date, re-notified June.
We did
not want to dismiss it today, but the tribunal traversed beyond future claim of Ayush. And how about what is his age, 5 years, whether he would meet that line? All this was irrelevant. They would have said that you are receiving pension, family pension of 13,000. So why should you be given the appointment? So far, so good. We are with the tribunal's reasoning. But going further has given you some platform to argue. He will answer. Let's see.
Only problem is what are she is
What is the problem? We have to go by legal. No.
That is why
But he has no place here.
Yes. Obligement.
deeply obliged.
Timing item 24.
अपलोड नहीं हुआ था क्यों नहीं अपलोड किसका था मिस्टेक asking to be particular, not this law. This water is clean. Something different, but how they know second? Well, fine. नहीं ये काम कर दो. It was a mistake of one of my most diligent, secretaries.
Well, it happens sometimes.
No, it happens, but it should not happen so far as this court number 1 is concerned. It should not.
It's a similar matter, Lordship. Out of those 48 persons, 2 had gone to court.
You have signed it on which group? उसी दिन कर दिया कितना दिन 12 दिन This order, this entering order could be challenged by the respondent, no? If it is not there, how would it get operated? It's a serious thing. We have restored the, direction of the tribunal to restore the basic pay has been stated. Then this order could challenge, order could challenge. That's the problem. This order has not been given effect to. The order passed by us on 18/3/2026 has not been given effect to.
Not yet, Lordship.
Actually, okay.
Lordship.
Every day, make a note how many orders have been passed and how many have been approved. Even every day I'll be asking you. But I need to be satisfied that every order passed today. They do it every day for 8 months. This is the first thing that I've seen, but who will justify it before I leave? No, and that responsibility is now of the court master. All right. The salary of respondent / Sri Surendra Kumar Bond was wrongly fixed after a promotion, after his promotion under the 6th Central Pay Commission rules. Which mistake could be discovered by the railways only in the year 2021? As a result of that, a correction was made in the pay, correction was made in the scale of pay of the respondent, reducing it retrospectively from 2009 onwards. Simultaneously, the railway administration directed the respondent employee to repay the excess money he had received over a period of 12 years. Bracket approximately 2.03 lakhs. This recovery, this reduction in the pay scale and the recovery was challenged by the respondent before the tribunal at Gauhati on the ground that it was unfair, illegal, and violated the judgment of the Supreme Court of Massacre. State of Punjab and others versus Rafiq Masih, bracket White, Osha, 2015, for SCC 334. The tribunal agreed with the respondent and quashed the order issued by the railways from restoring the higher salary of the respondent and directing the railways to refund the recovered amount to him expeditiously. Mr. R.K.D. Chaudhary, learned at CGC, appearing for the railways, has submitted that while the recovery of excess payment was not justified, but the respondent would not have a right to be paid on an incorrect grading of pay, which ought to be restored. The short prayer of the appellant thus is to interfere with the impugned order of the tribunal to the extent that the railways be allowed to correct, allowed to make corrections in the pay fixation without giving the liberty to the railways to recover the already paid excess amount. Let notice be issued to the respondent on steps being taken by the petitioner within a period of 2 weeks, both modes, returnable on 5/6/2026. Here we can't stay. Here we can't stay. You return the money, pay fixation will be done after a month. No need to stay. List this matter along with on 5/6
Flush.
Sorry, हमने आपका position पर नीचे कर
No,
दिया.
no, that's all right.
DSG.
That's all right.
Deputy Solicitor General. I'm so sorry. Not CTC. Deputy Solicitor General. Sorry.
That's all right.
May I please your lordship? My senior Mr. M. Mondal is on leave, lordship. And the matter may be, is on leave, lordship.
Your senior is on leave.
Yes, lordship.
Are you aware that the talks are still continuing?
Yes, yes. Well, what has happened actually, one group is, there are many matters. Some of them have accepted the land we have offered. Others are asking for land near the road. We are still searching.
Let's jointly prayed for. Let this matter come up for consideration. Let all these matters come up for consideration.
Let it come on 12th of May, because after the election, all this staff in the office of the DC will be, somehow DC will be counting here. 12th of
The early week of, first week of June.
It will be better. Okay. Well,
into 40.
Victims
Compensation and that's what perhaps you call this 7. I had compiled a chart for your lordships where I have done an extensive research on all the states of India, and everyone has a limitation period. Some of them
Everyone?
have- Every state has a limitation period prescribed. I'm placing that before your lordship. So the limitation period is different in each state, and it is.
Where is that?
I'm just placing the chart before your lordship.
इसको जरा format में डालिए.
Yes, Your Lord.
Put it in a format.
Yes, I'll put my way of affidavit, Your Lordship. Yes, I
Put it by way of affidavit.
I will.
Nonetheless, even if all states are erring, I mean, what would happen with respect to a case of kidnapping, where after 7 years, the man is reported to be dead or presumed to be dead? What will happen to that? I mean, only because others are following the same faulty way,
No.
That is no justification.
Absolutely, because
Put it on
the last.
Put it on record and you'll see.
Correct, yeah.
It's only with respect to section 7 of the
7 and 8, both on challenge.
7 and 8.
Only 7, madam.
No, in your case, only 7.
Only 7.
In Mr. Mandal's case, he is also challenged section 8 of the scheme, which is the appeal provision, basically.
In my case, madam, we have already challenged the clause 7, madam.
Ms. R.S. Chaudhary, who appears for Assam State Legal Services Authority, has submitted that she has made inquiries pan-India about these schemes formulated in different states. And in such schemes, in all the states, there is a period of limitation. Provide. Let such information be put on record.
Lordships would like to see these schemes as well, because when it becomes a voluminous document, perhaps I could keep it.
Keep it there with
in
you.
a private lordship. That suffice. I would definitely place the chart before your lordships, and the rest of the information I can give by way of declare black.
Yes, what did I say? By way of affidavit. By the next stage, read.
28 May.
No, Lordship,
Wait.
it's not.
Are you-
Above this one, June.
We'll say there is limitation period with provision for, relaxation.
Yes.
We'll see.
Yeah.
5-6.
Right. Deeply obliged.
Item 41.
Mr. Bota.
Your Lordship, kindly peruse the last order. Prior to that, your Lordship's order. Lord.
This appointment of Anganwadi Bhattar is for how many years?
Your Lordship, till retirement, 60 years. Your Lordship. On last occasion, your Lordship planning that to present.
Yes.
Lordship,
Yeah. Who appears for the state?
on last occasion, your Lordship, Lana Desi has appeared, your Lordship. And your Lordship has requested.
Now we know your arguments,
Lordship.
but response number 6 has Mr. Das.
Yes.
Perhaps argues that this recruitment was of 1919. The
Yes.
census which you have brought about is of 2021.
Lordship.
Correct. So therefore, there has to be a declaration. The selecting body cannot say.
That's why your Lordship.
Wait for the Advocate General to give us some light.
Lordship. Lordship.
Later. For the absence of the learned Advocate General, who had assured this court to clarify the stand of the state with respect to declaring a particular Anganwadi center as predominantly populated by SC community. The matter is adjourned. We'll keep it after elections.
Lordship.
In the meantime, response number 6 should continue.
Lordship, that's the DSC has been continued, your Lordship. There is no interim protect.
Keep it in June first week. Keep it in June first week.
If it can be in the month of May, your Lordship.
May. All right. Second, third week of May.
Lordship.
28 May.
Deeply obliged.
Item 42.
Pursuant to your Lordship's liberty minutes, we filed the documents of the way of an additional affidavit, the medical documents, which were originally not filed during the writ petition. Those we have filed. The documents are the mistake, the proposition, the proposition. I gave an actual spelling. But Ganguly, there are many mistakes in the spelling in my order. Look, one thing, there's a couple of things in the order. Mr. Chaudhary, Mr. Chaudhary is not here. What mistake? Minor mistakes which we could not see. But accepted proposition होता है, preposition लिखा होता है. 5 days and I had to spend approximately 8 lakh. Lordship will have kindly have page 4 of your Lordship's order of 2210. So there is one observation which appears to be contrary to the record. Okay, Lordship will kindly have that page 4. Lordship's order of 2210. Yes. Now this part, despite the fact that there was no evidence available on record about any negligence on the part of the Assam police or the necessity for opening fire. The negligence of the Assam police has been accepted by the learned single judgment. That this observation, Lordship's with my humble submission is not correct. It was on the basis of the negligence that the compensation has been awarded. This is internal page 4. Internal page 4 from the downloaded copy of Lordship's order 2210.
Last. That's fine.
Yes, what documents have you found?
No, I have filed an additional affidavit on 16/26. We have filed the entire set of documents that are in my possession, right from the first day in April 2017 till
Copy to it.
yes, copy.
Mr. Sharma, respond to this.
Why not? I have to take instruction on
Respond to this. You have to pay 3 lakhs more.
I'll take instruction on that affidavit in additional.
At least you must pay for the medical bills.
I'll take instruction on it.
Pursuant to the order dated. Ganguly, Mr. P. Ganguly. P. Mr. A. Ganguly. Mr. A. Ganguly, has filed an affidavit bringing on record have medical bills reflecting that he had to spend more than 8 lakhs for his treatment as a result of injuries suffered by police fire when he was not even a protester. He was not a protester, but only a bystander. Mr. Sharma, when it comes to protester, submits that we shall look into the documents, take instructions, and then get back to this format with this kind of state. Let that be done by the next day, May.
22nd May.
Second.
20. For hearing, item 44.
Yes.
Not necessarily remember the AG manner. He is not available. So Lordship can fix it in any other day, manner.
Yeah, looks not over.
No, almost. AG is the place on the respondent side.
Said that we have heard Mr. PJ Saikia, let's senior advocate, Mr. Katnia for this group. Mr. Naik sits and adjournment in the matter in order to address.
I think the main part of the last AG will look at it serious. You can make the employee of an assessment.
जो material उसको pass करिए. Mr. Psyche has to make out a case. You have to make out a case. Your term had expired. You say that this non-renewal is stigmatic. ये कैसे हो सकता है? How can you demonstrate that?
No, in fact, in the earlier occasion only I had submitted.
I think we remember there was some police case and then that could be the background, but that did not consider. Can we, assuming everything, can we ask the state to renew your contractual term?
No, here neither the appointment order nor the agreement nor the regulation provides that by lapse of the period in the agreement, co-terminus the serviceman.
Yeah, argument कैसे? How can you take this argument?
How
can you take this?
Because the regulation as well as the agreement speaks otherwise. It has to be continued by following the procedure mentioned therein. For a moment,
it was continued doesn't mean that there is a mandate to continue.
No, but
otherwise, what is the purpose? Why would you get a contractual appointment?
The procedure has been prescribed to follow in a particular manner. So that has to be followed. That is my submission. And my case is also slowly covers by that Sandrapaka's Sai case also. If you looks into the agreement itself, it is not a case that only my period has not been renewed. Throughout Assam, none of them were renewed. In fact, that is the practice in vogue. That is admitted by them. The process of renewal is on, and there is a procedure prescribed in the regulation as well as in the agreement. How to continue? For the purpose of discontinuation, they have to follow a procedure.
Well, what do you say?
Look, the period is over.
Who will appear in this one?
AG will come. This is because
Which date suits him?
no, let's say was on 28th.
Oh.
28th of April, madam.
As grateful on behalf of the 11th, let this matter be listed under the same heading on 28th
April.
of April in priority. They are prima facie, they are not finding any road. Let's see on that day you have.
On the allegation, they have made an inquiry. And
they may have.
And on that basis, they have issued a so-called. I have submitted reply.
Your only ground can be that you may have done whatever. That is always done. Departmental proceeding that you are anticipating may not, that you are expecting may not come. The only thing is that this is stigmatic, this is punishment because you were allowed to continue for 9 months without abruptness.
Exactly, madam.
That's the only thing. And that there is no legal framework to support that.
The Sandrapaka's Sai case exactly the probationer notwithstanding the expiry of the date of the probation period, he was continuing.
Anyway, we'll hear you on that day. Let's ask the general. But why was it adjourned for advocate? I think it's not a question of any concession or a big point or something.
Well, because there are many persons involved in the same issue, madam. At once, that's why, madam, 4-5% are on other petitions are pending, madam. They are basically these persons. This accountant.
Do is this: if Advocate General is here, so far so good. If not, take instructions and let's be done with this.